Dear colleagues, welcome to the Transnational Conference dedicated on children's rights, on the rights of unaccompanied and separated refugee and migrant children. We have dedicated this conference on the legal mechanisms, how to safeguard their rights, and especially the role of the Charter of Fundamental Rights of the European Union in the implementation of EU law and safeguarding the rights of these children. My name is Valeria Ivarova, and I'm the chairperson of the Foundation for Access to Rights, a civil society organization in Bulgaria that provides direct legal aid to refugees in Bulgaria. Currently, we provide legal aid in 5 regions in Bulgaria: Sofia, Plovdiv, Dobrich, Varna, and Burgas, with the kind assistance and support of our partner, the United Nations High Commissioner for Refugees. The occasion on which we gather today, and it is a privilege for us to have guests from, I would say, all or many countries of the European Union and outside the European Union, is a project that is co-funded by the European Union, the SERF program of the European Union. And this project is coordinated by FAR, the Foundation for Access to Rights, and it has several partners from several EU member states. These partners are NIDOS from the Netherlands. We have all their representatives here. ARSIS from Greece, Voluntarios from Italy, Terdezom Romania, CCAR from Spain, the Catalan Commission for Assistance to Refugees, and the Sirius Network, which is an international network dedicated on the education of refugee children. We had to change the venue of this conference in the last moment due to the recent developments in Bulgaria and the impossibility to have the event at the hall of the European Commission representation. However, everything works out for good because we are in the Magna Aula of Sofia University, which is considered the cradle of knowledge in Bulgaria. This is the oldest university in Bulgaria, and a university that many of us have also graduated. When we established the Foundation for Access to Rights back in 2013, the name, as you see, Foundation for Access to Rights, we were thinking, what is the Foundation for Access to Rights? Because there are rights in theory, which is very good, which is the achievement of the human civilization to have these rights stipulated in the laws. But our practice prior to establishing FAR, especially my work as a coordinator of the legal clinic at the Sofia University, had already revealed that it's not only important to have the rights on paper, it's also important to have access to those rights. So the next steps is to see how we can access, how the persons that we assist, the refugees and migrants, can access those rights. And one of the foundations for accessing the rights is knowledge. And the exchange of knowledge and dissemination of knowledge and experience has been one of the aims of this project, and is one of the aims also of this conference. When I was a student, always making now this connection while we are at the University of Sofia, and I became a student at the Refugee Law Clinic, I thought that this topic of refugees is something temporary, that now we have this conflict and it will pass and it will no longer be topical and up to date. But already for 24 years since I'm in this field, the refugee law and the refugee topics are always topical. Even now when greeting the guests at the conference, some of you said it's such a topical issue. And I thought to myself, I have always thought this, that now is a topical time for 24 years now. It's topical at the moment this year, but maybe next year it won't be that topical. But for 24 years, it continues to be very topical. And even now, I would say that we are even in a historic moment of the development of asylum and migration law of the European Union, because as you know, last year, 10 important legislative acts were adopted at the European Union, which are known as the EU Pact on Asylum and Migration. By the end of last year, we already have the national implementation plans of EU member states. And until June 2026, we have to follow these implementation plans to make sure that everything is ready in the EU member states in order to implement the EU Pact on Asylum and Migration. So it is inevitable that today we will touch upon this new development and also interpret it against the background of the Charter, which again reminds us which are the fundamental values that the European Union has achieved. And that is why I have put in the slide Article 24 of the Charter of the Fundamental Rights of the European Union, which is dedicated on the rights of the child. And I will read it out because I find it very important. Children shall have the right to such protection and care as is necessary for their well-being. They may express their views freely. Such views shall be taken into consideration on matters which concern them in accordance with their age and maturity. In all actions relating to children, whether taken by public authorities or private institutions, the child's best interests must be a primary consideration. Every child shall have the right to maintain on a regular basis a personal relationship and direct contact with both his or her parents, unless that is contrary to his or her interests. So when we implement the EU Pact on Asylum and Migration, we should remember that the Charter is always applicable. It's not only applicable, it's a primary source of EU law, and all EU legislation shall be interpreted in line with the Charter. Speaking about the foundations for access to rights, which are the necessary preconditions to make sure that people have access to rights, I mentioned knowledge already, but I also believe that it is very important to have practical insight. And this practical insight comes when you have direct communication with these human beings, with the refugees, with the migrants. The Foundation for Access to Rights way to have this direct communication with these persons have been by providing legal aid to them and through hearing them in this process. So this gives us extremely valuable practical insight how the law is being applied and how it should be applied. But that wouldn't have been possible if we didn't have the support in order to be present on the ground in these 5 regions in Bulgaria that I mentioned, with the support of our partner, the United Nations High Commissioner for Refugees in Bulgaria. And that is why it's a privilege now that I have together with me, Mr. Bülent Becker has kindly agreed, he's the vice representative of UNHCR in Bulgaria, and he has kindly agreed to co-open and co-inaugurate this event together with me. So I give him the floor. Thank you very much.
Thank you, Valeria. It's an honor to be here. And good morning, colleagues. Dobro utro to all of you. And welcome to beautiful Sofia and this beautiful building. I'm really happy that we are meeting here. And when I'm saying beautiful, I'm not repeating some cliches. I think cliches are important, but this is a beautiful gathering in a time when we feel that the humanitarian world is shrinking and is under a lot of pressure. Then our values of human rights, equality, gender equality, empathy itself, and solidarity are under attack. And what makes it, and I was talking to my dear colleagues from UNICEF just a moment ago on this exact topic. But our gathering is beautiful because it gives us a space for breathing. It gives us hope in terms of protecting the rights of children and gender equality and solidarity and a space for empathy for people who need our protection, people who need and children who need support to protect their rights. And in that sense, I'm really happy to be here. This is what we need. We need to be together. And this project, bringing together colleagues from Greece, Romania, from other countries in the EU, is for us a very important event in that sense. In Bulgaria, we have been together with FAR, together with UNICEF, together with the state agencies, IC State Agency for Child Protection, and colleagues from other organizations, from IAM as well. Here, we have been moving forward to change things, in the context of a crisis that is not maybe other than us, not spoken too much about the crisis of unaccompanied children, the disappearing children. And in my speech, I will speak a little bit more about that. But at the same time, in this current climate, in this context, I'm seeing a lot of hopes in the sense that we have, I think, achieved in this country, together with our state counterparts and together with the civil society, to move forward, to encourage the government to establish a working system. And it helps that we have many colleagues in different government institutions and departments who know the issues, who understand the issues, and who know the solutions. And that will help us to move forward. In Bulgaria, we are focusing on guardianship, to represent children's best interest, a case management system without which children will continue to disappear. And that's sometimes what people say, children disappear, children do not disappear, right? If we protect them, if we have a system, a case management system, referral pathways, and so on. That's where we're trying to go. And in solidarity also with our colleagues and government counterparts in Greece, promoting what has achieved success in Greece to inspire a functioning child protection system here. So with those words, I welcome you, and I'm really privileged to be here. Thank you very much.
Thank you very much, Bülent. Now we continue with the panels in the conference. The first panel before the lunch break is dedicated on the protection and risks for migrant and refugee children. And I kindly invite Professor Catherine Parin from the University of Lille, who is going to make a presentation on the situation of the children in EU asylum and migration law and the protection and risks under the EU Pact on Migration and Asylum. Then we will continue with the presentations by the speakers from UNHCR Bulgaria and UNICEF Bulgaria. We will have a coffee break at 11 o'clock, and then we will continue with the second panel on legal safeguards and the role of the judiciary, where we will have two interventions by Karolina Babica from the International Commission of Jurists and by Judge Cassandra Wanke from the Council of State in the Netherlands. So, dear Catherine, you have the floor.
Thank you so much, Valeria, for the kind introduction, and thank you for the invitation. It's a pleasure to be here today. I'm very grateful. It's my first time in Bulgaria, and to be in this beautiful place with this very distinguished and transnational audience is a real pleasure. I will try to address the issues of protection and risks for migrant and refugee children by focusing mainly on what the new pact is bringing. I don't know about you, but I'm not yet familiar with all the aspects of this very big deal. As Valeria mentioned, it is a package of 10 very dense instruments. So I'm still sorting it out, but there's a lot of interesting things when it comes to protecting minors. Not all of them positive, but definitely a lot of things that we can work with. So I will focus on this. I just want to first give you a brief overview of what we already have, so even before the pact. Of course, not an exhaustive study, but just to make clear that EU law was not designed to protect children. It was not the purpose of EU law initially at all. And yet here we are today, funded by the European Union, trying to advance the rights of unaccompanied migrant children. So there is a lot to be done with EU law, and it depends on how we use it. So this is why I first want to... Sorry. Toward this. Yes, thank you. So this is what I want to do. So first, briefly to recall what EU law gives to us in terms of tools to protect children, not only migrant children actually, but children in general. That's very important. And then I want to zoom in on the new pact. So Valeria already mentioned, of course, Article 24 of the Charter of Fundamental Rights. This is a huge achievement. Because again, it was not initially in the EU treaties at all, right? So we have had the provision on children's rights in EU law since we had the Charter of Fundamental Rights, and that has been binding only since 2009. So compared to the history of EU law, it's still relatively recent. Which is why I think it's also important to take a step back and keep in mind that this provision that we have in the Charter, so Article 24, it is actually inspired from another area, another level of law, which is the Children's Rights Convention. That's a UN instrument, so it's international law. In this Convention on the Rights of the Child, that dates back to 19. Sorry, 19. The end of the 80s, sorry about this. We had a lot of innovative provisions about children's rights. Protecting children as subjects was the priority of this instrument, to which all EU member states are parties, where we have provisions on the protection of children, on encouraging their participation, providing, of course, for their care, for their well-being, and of course, protecting and taking into consideration, as a primary consideration, their best interests. And so what we have in Article 24 of the Charter now is essentially a condensed version of this UN convention. And I think it is very important to keep in mind, also in terms of the hierarchy of norms, when we approach EU law, EU migration law in particular, that it refers only also to higher ranking norms. And for this, to apply these norms correctly and to make sure that we fully protect children, we can look, of course, to the guidance of the Court of Justice when it comes to interpreting EU law, but also to international law in a broader sense. And this is also very useful if we think, for instance, of all the guidance that we have from the Children's Rights Committee of the United Nations. So we have a lot to work with in EU law, but it's not only that. To focus a bit more on EU law, though, the Court of Justice made very clear, even before the Charter of Fundamental Rights became binding, that precisely the UN Convention on the Rights of the Child is highly relevant also in EU law. Okay, so even before we had the Charter, the Court of Justice had already begun to integrate the Convention on the Rights of the Child into EU law and to apply it in very diverse areas of EU law, actually. So not only migration, although that was the first area where the question arose, could we make use of the Convention on the Rights of the Child for family reunification purposes? Yes. And then it also got to be applied in questions that had to do with the internal market. So very far from asylum or migration. But that already began to show that children's rights are relevant all across EU policy areas. Okay, still, perhaps because of the nature of EU law, of the European Union, of how the competences of the EU are, decided by the treaties, there has been, and there still is, quite a fragmented approach to children's rights in EU law. So a lot was advanced through the case law. First, it had to do mainly with the rights of EU citizens and the rights of children who were EU citizens and could be protected also in their right to family life. And gradually, what we have been seeing in the past 2 decades is that so children's rights also apply in the EU's area of freedom, security, and justice, in civil justice, in criminal law, and of course also in asylum and migration law. And this is so now what we can work with. So not only the Court of Justice itself providing its interpretation of children's rights in those areas, but also another court, of course, which case law, which is also extremely important, which is the European Court of Human Rights, and which regularly, I think we can say, adds a bit of pressure also on the EU to make sure that children's rights are properly observed also in migration. And so that was the case, for instance, in the Tarakel case, which the Court of Human Rights adjudicated concerning a family that was being subject to a transfer on the basis of the Dublin regulation. And more recently, the Court of Human Rights again insisted on the specific extreme vulnerability of children in the migration context. And this is not always repeated as such by the Court of Justice, but still we can see increasingly in EU law that migrant children are recognized as vulnerable. And this concept of vulnerability can also be very useful from a legal perspective to protect the children. So in this respect, perhaps you have already heard of this case, but I think it's a very interesting one of the Court of Justice from 3-4 years ago that made very clear. So here it was in the migration context, that the best interest of the child, according to Article 24 of the Charter, but also based on these other instruments, so also on the ECHR, also on the United Nations Convention on the Rights of the Child, that the best interest of the child must be a primary consideration in any decision that concerns the child, even indirectly. So in that case, in this MA versus Belgium case, a return decision had been issued to a third country national, not a child, but the child herself, who had a right to reside in Belgium, would be deprived of her parents if the return decision was indeed being executed. So the court here said, even if the person is not a child, himself or herself, but the decision in some way will affect the child, then the best interest of the child also must be a primary consideration before reaching the final decision. And that has been quite a revolution for a few member states where that was, I cannot speak about all 27 member states, but for sure in Belgium it was a small earthquake, in this area. In Luxembourg as well, where I practice law, it was this decision was greeted with a lot of interest, but also with some degree of surprise. Oh, so we have to also take care of decisions that, or of how children are indirectly affected by migration or return decisions. That was a big deal, let's say. And there have been also, of course, a lot of other interesting cases. Not all of them have to do with what EU law calls migration law. Okay, sometimes it has to do with the mobility of EU citizens. So there is this quite famous case about a Bulgarian family at the Court of Justice concerning the right to move. So for an EU citizen child, but across the EU, here too, the best interest of the child must be taken into consideration, so as a primary consideration. Here too, the Court of Justice interprets not only the Charter itself, so Article 24 on the rights of the child, but also the Convention, so the UN Convention on the Rights of the Child. And the Court of Justice even uses the comments of the UN Committee on the Rights of the Child in its own judgment. So there is really, as I was saying, there is a lot that we can use, even when we are, applying EU law, so a specific instrument of EU law, whether it has to do with the Citizens' Rights Directive, or whether it has to do with asylum, with migration instruments. There is a lot of other higher ranking norms that can be used and that the Court of Justice itself uses. So not to give you a too long a list, if you are interested in the slides and in the references, of course, we can make them available, I'm sure. But just to insist slightly on how the Court of Justice is consistent when it comes to the rights of the child across policy areas. So here, why do I insist on this? It's because EU law has its own categories, right? And so as I was saying initially, it was focusing, so the EU focused mainly on the internal market, on economic priorities. Gradually, it built other policy areas, including migration and asylum. But let's say the child was not, let's say, the main priority in terms of categories of persons to be protected in EU law. But what we see in the case law of the Court of Justice is that it tries at least to be consistent, to give the same interpretation of what are the best interests of the child or how to use them, whether we are talking about civil matters, whether we are talking about citizenship, or whether we are talking about the rights of migrant children to be reunited with their families, to be treated according to their interests in a Dublin procedure, etc. So in the current system already, there is a lot to work with from the case law when it comes to fundamental rights of the children. Sorry, just one thing that I want to mention. So here it's in French, but just one small mention, an example of how the progression that we have at the Court of Justice is also reflected in national legal systems. So perhaps you will have examples from your own member states. But in Luxembourg, it has been quite interesting to see how the courts respond to the case law of the Court of Justice on the rights of migrant children. The example I have here is precisely shortly after this case I mentioned on the return decision that was sent to a parent of a child, the child not himself being concerned by that return decision. And in Luxembourg, so far, until that judgment, the Luxembourg authorities had been doing exactly like the Belgian authorities. And after the judgment of the Court of Justice was issued, the lower courts immediately reversed their case law. They did not even wait for the higher administrative courts in Luxembourg to alter the case law following the Court of Justice's judgment. The lower courts themselves immediately said, okay, so now we set aside the existing national case law and we apply this principle that the best interest of the child must be a primary consideration in a return decision, even if that return decision also only concerns the parent. So again, perhaps it doesn't work as smoothly in all member states, and it's certainly not always the case in Luxembourg either. But still, there is a palpable influence of the case law of the Court of Justice when it comes to protecting children by applying Article 24 of the Charter. So all of this, of course, we can take with us when we look at the new pact. So here is this is the list of instruments of the new pact. As I was going to say, it's not going to be an exhaustive search, exploration of all of these instruments, but just so that you have them in mind a little bit. We have a lot to work with. We have the Asylum and Migration Management Regulation, which is essentially the successor to the Dublin III regulation. We have a new asylum procedure regulation that replaces the procedure directive. We have a crisis and force majeure regulation, which will allow for derogations from the other instruments. The Eurodac regulation that complements the AMMR. We have a new screening regulation that will be applied probably at the beginning of a process to determine whether someone should be channeled to an asylum procedure or perhaps to another procedure, essentially a return procedure. We also have a new qualification regulation that replaces the qualification directive. We have a recast reception conditions directive. and there is a non-compulsory resettlement framework. And in all of these instruments, there are mention of children's rights. Not always in the same way, not always fully consistently, but they are in all of these instruments. So one of the challenges, of course, would be to apply all of these consistently when it comes to the rights of the child. And it's not only about like specific provisions that tell us what to do with children, although that's of course very important, but also all of these instruments make references and quite a few references to the Convention on the Rights of the Child and to Article 24 of the Charter of Fundamental Rights. So again, the importance of both these sources of children's rights, not only the Charter, but also the UN Convention, which is more detailed, so that can also be interesting, are recognized in the new pact. We can find them in the many reference to these provisions, so the CRC, and Article 24 in the preambles of the various instruments, sometimes even in the provisions of the binding provisions of the instrument themselves. So that's, I would say, good news. Okay, we have a hierarchy of norms that is recognized, that is fully embraced by the new pact. And then, of course, we have something that is also a very interesting evolution in the new pact, which does not only concern minors, but certainly will be also of interest for them. It has to do with the concept of vulnerability, which is already present to a certain extent in the current system, but which will be reinforced with the new pact. What is it to be vulnerable? Well, unfortunately, there is no definition of that in the pact, but at least we know that there is a notion of vulnerable persons having special needs that need to be addressed by the asylum authority or the immigration authorities. And so we have lists, depending on the instruments, the lists are not always exactly the same, but we find children in all of these lists of vulnerable persons. So children are recognized, I would say quite consistently across the instruments of the new pact, as being vulnerable and therefore having specific needs. So this is something interesting, as I'm saying, at least complementing the specific provisions on minors, because when it comes to vulnerability, we have also a lot to work with. And so we need to, again, it's not an easy task, but to make connections and consistent connections with all of these notions. Oops. Yes. So why is vulnerability important? So this concept of vulnerability, it's not only an empty shell or an empty word, there are some real operational consequences that are attached to it in the new pact. And these operational consequences also work for children. So what is very common now across the various new pact instruments is the need to have staff that is trained. So staff in the administrative authorities, all of the authorities that deal with asylum applicants, and more broadly actually with third country nationals who will be going through at least one of these procedures foreseen by the new pact. The staff needs to be trained. So if it has to do with, if they are dealing with minors, they will need to have appropriate training, so to be able to implement child-friendly procedures and to know what are the special needs of minors and how to address them. And the detection of vulnerability must happen throughout all of the new pacts. So at the different stages, no matter which instrument you are looking at, whether it is the screening regulation, whether it is the procedure regulation, whether it is the qualification regulation, so seeing whether someone or not is entitled to protection, and then what will be the content of protection and how this will work in practice. At all of these stages, there needs to be an assessment of vulnerability, and then, of course, an adequate response to this. So for children, for instance, and especially if they are unaccompanied, it will lead, for instance, to designating a representative under, now with the new pact, much more stringent conditions than what we have known so far. So there is this notion of vulnerability that reinforces or at least that has the potential to reinforce the protection of vulnerable persons, especially minors. And here we have, so the slide is quite heavy, and yet it's not all of the provisions that we can find in the new pact, but just a few examples here. In the crisis and force majeure regulation, so when it comes specifically to minors, we know that the crisis and force majeure regulation is supposed to have to allow member states to derogate from the other instruments of the pact in the event of a crisis or force majeure. Well, even in those situations, minors below 12 and their family members, if there are any, are not to be subjected to a border procedure. So there is a protection that is foreseen, at least for minors below 12. That's not all children, and that was actually quite controversial when the pact was being negotiated, but still, that's the protection that is foreseen. If you look at the screening regulation, a new mechanism of monitoring fundamental rights will have to be implemented in each member state. And that mechanism, it could be an existing human rights institution that will take up these new tasks that will depend on each member state. In any case, this new or not new, but mechanism with new tasks will have to notably check whether the best interest of the child is being taken into account, so as a primary consideration in the various processes. In the RAM, so the regulation on asylum and migration management that replaces or that succeeds to the Dublin regulation, there are now much more detailed provisions on the best interests of the child and how to assess those interests. So you have a much more detailed, longer list of criteria that national authorities can use or should use actually to decide what is the best interest of the child. In the procedure regulation, you have also a lot. Basically, the system does not radically change, but it is much more detailed. So we know with a lot more precision how, when the representative of an unaccompanied minor should be designated, so that is in the maximum of 15 days. There are new guarantees that are added, such, for instance, the representative should never represent more than 30 unaccompanied minors at the same time. So that also is supposed to ensure the quality of the support that is given to unaccompanied minors. Okay, the list could go on because there are a lot of these new, more detailed provisions in the pact. But I hope you can see that there are indeed some new tools, so no overhaul of the system when it comes to minors, to unaccompanied minors, but many new interesting developments, more details that, of course, member states will have to implement, and that can contribute to protecting minors, especially unaccompanied minors, more effectively. Now, of course, there are still some issues, some challenges that the questions that are raised by the new pact that need to be addressed. One major issue to which there is no, at least in my view, no convincing solution in the new pact is the question of how we identify children. So if a minor or if an applicant for international protection claims to be a minor, but the authorities don't believe him or her, there is a procedure. It is a bit more detailed than in the previous version of the asylum, and then in the previous asylum procedures directive. But still, even the recital of the regulation, so the procedure regulation itself recognizes that there are still some gray areas, and that there is no miracle solution apparently to make sure that member states will actually comply with the presumption of minority. So that's in the regulation, okay, that if someone claims that they are a minor, they should be considered as such until an assessment says otherwise. But we know, at least, I don't know, in Luxembourg we know, and I think it's not only in Luxembourg, that this doesn't work very well in practice, and there is no miracle solution so far to tackle this problem. So that will persist. Also, the persisting possibility to detain minors is, of course, a problem. It is supposed to be a measure of last resort, but still it is possible when detention is assessed to be in the best interest of the child. That raises a problem, especially if we think of the relationship between EU law and other legal systems, especially the UN Convention on the Rights of the Child, of course, since the UN Human Rights, Children's Rights Committee itself has published statements and been very clear that detention is never in the best interest of the child. So how do we reconcile these various sources of law? Perhaps at some point the Court of Justice will have to clarify this. At least for now, it is definitely an open question. There are also other questions. So member states now have a bit more leeway to assess situations where you have a married minor. So this is a bit controversial. It could go either way. So either protecting the right to family life of that minor, allowed to bring the spouse, or not if that minor is with his or her parents. This is a bit blurry, I would say. And the last, or no, not the last, but the last of my list, which is not an exhaustive list of questions that arise with the new pact, is what happens with unaccompanied minors who are not asylum seekers. So here you have quite a degree of diversity in the various member states, but in many, so including Luxembourg, if you have a third country national who is an unaccompanied minor and does not ask for asylum, that person falls into a complete legal vacuum. Yet, if you look at the situation from the perspective of children's rights and not primarily from the perspective of migration law, and you perform a detailed assessment of the child's interests, it might not be in their best interest to apply for asylum, simply perhaps because they don't fit the criteria. And for this, the new pact doesn't say much. We know from the new draft return regulation that has just been leaked or published, I'm not sure if it's fully official, but there is now a new return regulation proposed by the Commission to return to their countries of origin, third country nationals who either have been denied asylum or have never applied for it and are not allowed to remain in the EU. In this new proposed regulation, so that's not part of the new pact as it was adopted, but it's forthcoming. It's perfectly possible to detain minors pending their return, and it's also perfectly possible to send unaccompanied minors back to their country of origin. The only thing that seems off the table based on this new draft, so that should replace the return directive, is that minors, at least unaccompanied minors, will not be concerned or will not be the subject of what is being discussed at the moment, returning to third countries, so to hubs, before they then are sent back to their real country of origin. So this kind of temporary transit country, that should not apply to minors, at least that is what is foreseen in this new draft. That is, of course, still subject to change. But also here, we have to see how this, so first what is adopted and then how it is applied in practice. So this is what I wanted to present to you today. Just briefly to conclude on how I think we can address these future challenges is, of course, to keep in mind that so childhood is one form of vulnerability, and it has to be connected with other factors of vulnerability. So whether it's disability or being separated from one's family, that's also a factor of vulnerability. So there is this need for an intersectoral approach that the pact allows, so we can do that if we want. It's also important to keep in mind the connection between the different instruments of the pact. So between the screening, what replaces Dublin, the asylum procedure itself, ensure consistency to ensure that no one falls into a gray area or is left outside of a procedure. And then what is, I think, very useful to advance the rights of the child is to mobilize EU law, but not only. So to also think of how EU law connects to international law, especially the Convention on the Rights of the Child. And then that could be food for thought and tools for work, for practitioners, and also for courts who will interpret all of these things. So thank you very much for your attention, and I look forward to the discussion.
Thank you very much, dear Catherine. You have given us a very solid framework about the interaction of EU law, international law, and the national systems in making the rights of children effective in the implementation of national law and the added value of EU law. It has been really food for thought and great for lawyers as a lawyer. I really enjoyed it. Thank you so much. Now we continue and we give the floor to Violette Becker. We are going to put on the screens the presentation. Yes,
Okay, thank you very much for this very informative and systematic presentation. It gives context to my conversation and allows me not to focus on legal specificities. Indeed, the EU Pact on Migration and Asylum provides us new opportunities. Of course, there are also risks in the EU Pact. UNHCR has negotiated the pact as in terms of its supervisory function and the mandate under the EU law. And the pact files that we have reviewed a moment ago contain 48 provisions on UNHCR's mandate and role, which includes actually an important point, I think, which includes the organizations acting on behalf of UNHCR. That's a very outdated EU legal term, which in UNHCR's reading means any partner from international organizations to refugee-led organizations and volunteers who are part of the refugee coordination structures in countries, right? So for us, it's more sort of flexible term. It does require a declaration that an NGO or a specific party is, an organization is acting on behalf of UNHCR on a specific issue, such as one of the things we're advocating, and I'll come to that, for instance, being involved in vulnerability screening, right? Which is very central to the functioning of the pact and the functioning of the pact in a way that unaccompanied children at risk in general, are receive protection under the reception conditions, for instance, specific material reception conditions, and so on. And as you know, under the pact, there are certain risks when it comes to detention of children, because it's not absolutely prohibited. But of course, we then have the European Court of Human Rights case law where we can fight against. But using strategic litigation, that's something we do together with FAR as well, to fight so many violations is a bit exhausting and very resource demanding. So I'll go to the first slide. I'll start with data to give a picture. I was talking about a crisis in Europe, not only in Bulgaria. That crisis has always been there, right? At least like for 70 years of our history, crisis of child protection crisis has always been there, but it became more visible and escalated since 2015. And I wanted to start with this, and just a precaution here. I may need to make some caveats in terms of data quality. In the European Union, UNHCR does not do case management. In many countries outside of EU, we use either UNHCR or UNICEF case management systems. In the EU, we don't. We support governments to establish case management systems, data collection systems, but we don't. So we do information management in Bulgaria. So you see here that that more than 13,000 unaccompanied children have applied. Of course, the number of children who went through Bulgaria, these are children from Middle Eastern countries and Afghanistan, and very small numbers from North Africa, African countries, and Pakistan and Bangladesh and so on. But the majority of these children are, as you will see, are from Afghanistan and Syria, followed by Egypt in 2024 in particular, and Iraq from the beginning. And I'll specify these figures a bit more in the next slide. And you see that the majority of these children are at the age of 16, 17. Why? Because they belong to families who have been displaced over a long time. since 2011 in the case of Syria, right? In the case of Syrian Kurds, even longer. In the case of Afghanistan, these children were born, many of these children, UNICEF, as you know, interviews many of these children in different countries throughout their journey and produces data, produces participatory assessments. And as someone who interviewed children from Afghanistan, from Syria, in much of my career, including in the EU, I can say that these Afghan children were mostly born in Iran and in Turkey, and their parents were born in Iran in most cases. And as displaced persons, they were deprived of their rights. They were not. They had very limited access to education, and these children, many of them starting working at the age of 5 in sweatshops that produces nice products for Western European countries. By the way, I cannot avoid saying things like that. My grandmother always said that I should speak about good things, not good things, but sometimes I forget that, in sweatshops. So they have been deprived of personal development opportunities and education opportunities, right? And in the EU, I'll speak, since I'm part of the Bulgarian society, I'll speak earnestly on what's happening. I think there has been a burnout about the systems not very well functioning, and there was a presumption that Bulgaria is just a transit country for children. That's not our finding. We find that 79% of children, when they come to Bulgaria, they come with an intention, the hope that they will build a life. They will go to school, they will find jobs. So 16, 17, they will find jobs and they will send money to their families. They are not coming to Bulgaria to go to another country, right? Just to make that clear. There are 6% who are coming for family reunification purposes through irregular means with the help of smugglers. So that's another category in this. But this 16, 17-year-old who have been deprived of personal development and education opportunities is very important for us to understand. And in the absence of services, in the absence of access to their rights, they are the only resource, the only adults in their lives are often smugglers and traffickers, right? We have anecdotal evidence that in the EU, what's happening to some of children, especially Afghan children, is, again, sorry for getting my grandmother's advice, they are being raped, filmed, and blackmailed into crime, including crimes that are listed as national security crimes, terrorist crimes, right? I mean, of course, not all of us children, just have a breathing space, but that's happening. Right? Then we hear about them, then they stop someone just as the elections are coming. I don't say any of these things, by the way, just like very confidentially, we are among ourselves. Nothing to quote on this, just to make sure. In 2024, just to see a couple of changes, Egypt suddenly became a prominent country. In Bulgaria, we mostly have children transiting through Turkey, which is now both Turkey and Egypt are trying to control by introducing new measures. But also in Greece, we have Egyptian children coming through Libya, which means a lot of things that, following the advice of my grandmother, I'm not going to talk about, and it's not relevant in this situation. So you also see a decrease in the numbers because there was 67% decrease in asylum applications in Bulgaria last year, with the increased Frontex presence and with increased controls on the part of the side of Turkey. The asylum procedures, what's happening in the asylum procedures? From 2021 to 2023, Afghan children for recognition rate, protection rate for Afghan children was almost 48%. For stateless are Palestinians plus stateless refugees, 100%, and for Syrian unaccompanied children from Syria, 99%. So you had protection if you are unaccompanied children from Syria. But changed in 2000. For Afghan children, 4%. Syrian children, 57%. There is, in general, in the EU, we see declines in protection rates. But I think this is, especially when it comes to Afghan children, it's a bit dramatic. And that means, in particular terms, children not waiting for their decisions, right? So, so the smugglers have more leverage here to tell children, okay, let's go to Germany. I'll take you to Germany. We don't know that, because when we say out of 13,000, we can identify now in Bulgaria, let's say over 600. Many of these children have become adults and so on. Some of them are in Bulgaria, some of them are in Germany, but we don't really have data, which gives a big space. I didn't talk about the connection between the pact and the anti-trafficking directive, but maybe later, a couple of words on that. So we don't know the number of children who are in the hands or who have been in the hands or who are in the hands of smugglers and traffickers. I think in the current world, the distinction between smugglers and traffickers may not always be what we see from the legal perspective, right? Just to put these numbers, asylum protection rates in perspective, what happens, so UNHCR monitors with, of course, very limited resources and with the help of our partners, in this case, Bulgarian Helsinki Committee, we monitor from the border through the asylum procedures to the return. We monitor the whole process that comes under the pact now, the Common European Asylum System, and linked to that, the management system. So we see that only 3% of children were interviewed in child-friendly rooms that are appropriate to interview children. Child-friendly techniques, 55% looks into one aspect of child-friendly procedures. But one thing that is strong, and I'll mention that when I talk about the strengths of the system in Bulgaria, that legal representation works in Bulgaria, which we don't have in every country. For unaccompanied children, legal representation works in Bulgaria. We don't see that in many countries. Best interest, fundamental, as I said, fundamental to the to child protection and to the EU law. In 50% of the cases, best interest was included in the files that we have monitored. So that means that because an asylum claim should be examined in light of the best interest of the child. And all decisions from border to return should be made in line with best interest. And there are a lot of reasons behind this, right? The endemic problems, which goes to the financial situation of the State Agency for Refugees, and the difficulty of keeping experienced staff, and the difficulty of Yeah, you have to speak to them. I'll stop. Okay, so children, just one slide to when we speak about unaccompanied children are very, very diverse, right? And not only unaccompanied children are at risk. And we can talk about, I said vulnerability assessment is your entry to many of the rights, many of the specific treatments that children receive under the pact, under Bulgarian law. Bulgarian law is very, very strong, by the way, when it comes to child protection. You have I couldn't organize this under the pact, under reception conditions, under screening, under asylum procedures, and so on. Many of them are cross-cutting. Okay. So again, as a context to what I'm going to say about our position on the international implementation of the pact in Bulgaria, just to see the risk, as many of you know better than me, the risk is higher when children don't go to school, when there is no case management, when children cannot access state authorities and other stakeholders, UNHCR, NGOs, and so on, right? The stakeholders that are normally involved in supporting a case management system. And in Sofia, if you go to Jenski Bazar area, you will see that there are many children who are not even in the system, like they haven't applied, they are waiting for a smuggler to take them to another country. Actually, once we have a Compass Protection and Inclusion Hub, is still evolving in the Jenski Bazar area, very small place with the Bulgarian Red Cross colleagues with years and years of experience working there. And I saw myself, 14-year-old Syrian boys brought by someone, actually a Bulgarian citizen who said that who didn't know his children. So it's very important that we make sure that when someone brings children, or when children wants to approach and come under the state protection, they have these opportunities, right? In this case, they were registered by the colleagues and in our system, and then taken to the safe zone in Buena. We have two safe zones in Sofia. Yeah, Buena and Ochakov. And one of my colleagues is actually working with these children in Ochakov. I don't know if it's still the case. Okay, so as I said, we have very good things, and one of the very good things in this is the social workers working with these children in the safe zones. I will be, if I have to speak about safe zones as a primary response to children, I will be very critical. But at least that's something, and the relations with the social workers and cultural mediators working in these zones, both IOM and State Agency for Refugees are the only adult relationship that these children have, which came through very strongly in our last participatory assessment with children, which is called Voices of Child Refugees in Bulgaria. Okay, so strengths and weaknesses, opportunities, and threats. So as I said, child protection law, so like that spans through different instruments, family law and law on refugees and asylum and refugees and so on, is strong. And legal representation, as I said, is exemplary, one of Bulgaria's best practices that can inspire other countries. And weaknesses, as I said, we're talking among ourselves. I'm being frank. Some of my colleagues from the state institutions know that these are my standard statements. So they are not offended. They know this. I learned this. What I'm saying, I learned from them, right? And best interest and case management, I would also say that this is an opportunity, not only a weakness, because I think now there is an understanding, now there is an increasing effort on the part of the state authorities to make it work. And I think both UNICEF and UNICEF partners are here to support this. And EU Asylum Agency, which is providing operational support to the State Agency for Refugees, has actually, upon request of the State Agency for Refugees, prioritized child protection as one of the areas that they are going to support the government. Inclusion and integration. Without inclusion and integration, children do not have a perspective. So as I said, then we are strengthening, we are leaving a big vacuum to criminal networks who are stronger than us. They are stronger than us, right? In terms of financial resources, in terms of networks, they are stronger than us. We are stronger as a community here. We are strong in terms of our values and our passion and our commitment, our experiences, right? But when I worked on trafficking before UNHCR 30 years ago, maybe, I was always told by the police, just keep away. You cannot protect yourself and we cannot protect you when it comes to trafficking. Opportunities, the coordination mechanism. That's key. When you look at the success of the National Emergency Response Mechanism for minors in Greece, right? The coordination between all the stakeholders that is now managed by the Undersecretary of Vulnerable Persons under the Ministry of Migration and Asylum. That's the strength, and that exists in Bulgaria. It just needs some rethinking, I think, and a process that makes it effective. Because when we say there are legally and in terms of the technical experts working on issues, things are there, and that gives us a lot of hope in terms of what can be done to make sure that we know where every child is. Children should not disappear, They're small. Some of them are big, but many of them are small. They should not disappear. Mandatory reporting. I would say this is strength, but also an opportunity because it's not really, it's not functioning when it comes to refugee children at risk. Children at risk even though international protection, broader term than refugees. And care arrangements, there are safe zones, right? But children shouldn't stay there for 6 months or 1 year, 2 years. That didn't here. And expanding space with the support of UNICEF and IOM, the alternative and in terms of advocacy and working with municipalities, also UNHCR, the expansion of alternative care is a huge opportunity for Bulgaria, and there are resources for it. But I said not strength, but opportunity, because only few children are in alternative care, and children are still disappearing from safe zones, and also we need standards and supervision when it comes to alternative care, and that's one of our key asks in relation to the national implementation of the pact. And guardianship, I think the law on guardianship in Bulgaria can already provide effective guardianship in Bulgaria with training and with standards and with the supervisory institution. Another key ask of UNHCR in relation to the implementation of the pact, in particular the screening regulation, asylum procedures regulation, and the reception conditions directive. And the risk, I have been saying from the get-go, trafficking smuggling, but also securitization in the public discourse of unaccompanied children, especially boys. What UNHCR says very briefly, of course, the refugee coordination model that doesn't only that also speaks to actually energized by the focus on Ukraine refugee situation. I didn't talk much about unaccompanied children from Ukraine. We had 530 over 530 unaccompanied children registered. Now we have 33, I think, but over 30. But there are unaccompanied children, especially 16, 17, including those in universities who do not register. They don't want to be part of the, they don't want state protection. They're worried, so, but our Compass and Protection and Inclusion Centers, for instance, in Plovdiv, Ukraine Support and Renovation Fund, a refugee-led organization, has reached out to some of these children without convincing their parents and them to get into the state protection system, but still there was a level of protection. So NGOs can do a lot actually in transition to the perfect world that we will establish in Bulgaria one day. And as I said, UNHCR, I think one important thing that we are proud, if you like, is that we are monitoring from entry to return procedures. Not perfect, but gives us a lot of perspectives and facilitating state to member state. As an example, in the case of Greece. Okay, so this is a summary of 100 pages of UNHCR recommendations on the national implementation of the pact. Don't criticize because like the pact is I don't know how many pages, 1,000 pages. So this is just key highlights from what we prioritize in with regards to the national implementation of the pact. So effective coordination mechanism and resources to support that coordination mechanism, right? And best interest from entry, and that speaks also to the vulnerability assessment. One thing maybe to say with regards to vulnerability assessment and probably also about best interest, our recommendation is to engage what is called in the law organizations acting on behalf of UNHCR. So these are Bulgarian civil society organizations with expertise in child protection, with expertise in identifying red flags of trafficking, red flags of trauma, and so on, right? This is for us very important, not only the border police, in the case of the screening regulation, but also the other institutions, including Bulgarian civil society, the experts in these organizations, and cultural mediators. Right now, we don't have interpreters and cultural mediators at the border, in detention facilities, and so on. The communication with children and their identification in detention is done by NGOs, just to make that clear. Child-friendly asylum procedures, as I would also highlight that, as I said, that's really affects whether a child can present their claim or not, or we can obtain enough information about to be able to assess their protection needs. So that's child detention. In Bulgaria, as soon as you identify unaccompanied children, which in reality is done by NGOs in the absence of interpreters. Unaccompanied children are, and the term unaccompanied children is very wide in Bulgaria. It also includes separated children, so that's an advantage. They are released from detention, so maybe 5-6 days, 1 week, not more than that. Long period for children to be in detention, but at least there is this safeguard. But children with families, last year, more than 340 children were in detention, including 5, 6-year-old children, on account of their parents' migration status. Mostly Afghan, as far as I saw myself. So that's an important thing to deal with homework for the stakeholders in Bulgaria. And access to education and personal development, I think that's a huge and very important point that comes more strongly with the fact that we will pursue, and we have made very detailed recommendations, and we'll continue to all together continue to expand on that. So I think I'll leave at that. I hope I didn't use too much time. Thank you very much.
Thank you very much, Julian. Children should not disappear. This is the key message that I would take from your in-depth analysis of the practical situation in Bulgaria and more broadly, which reveals why we need these legal safeguards. Thank you very much. And now we give the floor to Laura Voinova, who is the Child Protection Officer at UNICEF Bulgaria.
Thank you. I'm given the difficult task to wrap up this session and to do it in a very concise manner, because I realize that it's me and the coffee break. So I will do my best to be really concise. First, let me thank you for being here. I think this is a great opportunity to share our experience and to see how further we can continue in ensuring that unaccompanied children are really given the best opportunity and protection. We've already spoke about the EU Charter of Fundamental Rights. We did talk about the CRC, and we always bring the best interest of the child. But what it really means is the big question. We all know that all children should be treated equally without any discrimination. But what we see is that children in the context of migration usually, and especially in practice, are not treated the same way. And what happens is that they're often excluded from the national child protection systems. And the child protection system is the one, especially in a functioning EU member state, that is responsible for the case management and for the best interest of the child. Without that, we cannot proceed. What we really need to do is to shift the paradigm. We need to shift the paradigm and start looking at children not through only the migration lenses, through border controls and asylum procedures, but as children, because they are children first and foremost, and they have their rights. It's not easy. We've been seeing that. It's always the big battle between migration and rights. And here we have the perfect opportunity with the EU Pact on Migration to at least try to ensure that the best interest of children, especially unaccompanied children, are given primary consideration as it should be. Bülent has rightly mentioned that Bulgaria has been experiencing an unprecedented migratory flow in the past several years, and the number of unaccompanied children has been also on the rise. That inevitably has put a big strain on the national reception and asylum system, but also on the child protection system. The child protection system, which is the responsible for case management, again, to remind you all, and assessing the best interest of refugee and migrant children. And what is the child protection system? What makes it strong is, what is the backbone of the child protection system is really its workforce. This is the key ingredient to ensure that the needs of children are assessed and taken forward. In Bulgaria, our national child protection system has been faced with numerous and I would say systemic issues, which lead to high turnover rates, to unpreparedness of the child protection departments, to lead on specific and difficult cases, such as the ones of the unaccompanied children. And I'm not blaming them because they're the ones who are at the front. They're the ones who need to deal with all the cases of children at risk, children victims of violence, children in parental conflicts. They're the ones who need to deal with everything, and refugee and migrant children without the necessary support, without the preparation, and without the motivation. So here, I don't want to sound grim, of course. Yes, we do have a lot of challenges. Yes, if we want to ensure everything that we've been discussing so far and make sure that there are proper safeguards for the unaccompanied children, we need to invest in our child protection system. We need to work with it. We need to make it realize its importance and its role. And yes, a lot has been achieved. We have managed to improve the reception conditions. We have the safe zones. They're not perfect, but everything is far from perfect. We don't live in a perfect system. At least we try to ensure better care and protection for the unaccompanied children while they're in the reception centers. Alternative care. This has been something that we would never think of 5 years ago. An unaccompanied child placed in a social service in Bulgaria, that would be rare. Now we have specialized services which are only for unaccompanied children. And we have 6 more that will be developed soon, hopefully. And we are diversifying it. We also try to diversify and ensure that our foster care and foster parents are prepared and also have unaccompanied children placed there. So far, that hasn't been very successful, but it's moving and we're in the right direction. What about representation? Yes, effective guardianship mechanism is the key to ensure the best interest of the child. And yes, ours is not perfect, but do we have a proper representation mechanism in place? We do, in comparison to 5 years ago when we didn't have any. So we move, we try to improve. It's not easy. This is a very lengthy and difficult process, I would say, and it will not happen overnight. It is definitely now the time to really reassess what has been achieved, what remains to be achieved, and to make sure that this takes place in the national implementation of the EU Pact on Migration. So how do we do it? What do we continue to do together? Because the key is to remain united, to put children at the core, at the center, and to consider children, migrant children, unaccompanied children as children first, and not based on their country of origin or their legal status. We need to continue to invest in the different forms of alternative care, be it foster care, be it small type centers, be it kinship care, because this is also a form of care that is really underdeveloped in regards to the unaccompanied children. Guardianship, definitely. This is definitely an area where we need to work more. We need to ensure and support the child protection specialists and professionals that are at the forefront, that they're equipped, they're trained, they're prepared to respond to the specific needs of the migrant children. And we should not forget that we need to work with the local authorities and the local populations. Without them, we cannot achieve any of that. It is the local communities and the local municipalities that are at the forefront as well and are the ones who accept and allow for the meaningful integration of these children. And as a summary, I hope I didn't take too much time as I promised. Really, We need to have a stronger collaboration among all of us so that we can continue the good work. And again, a child is a child, and we shouldn't forget that. Thank you.
That's a very key timeline, and usually we speak about seeing the human in the refugees and migrants that we work with. And you reminded that we should also see the human in the persons, in the social workers that work with these persons, that they are also human and that we should invest in their preparation and motivation. That's a very good reminder in this discussion. Thank you very much. Now, we would like to dedicate some time for your questions for a discussion. There is a microphone here at the table that we can use to give to the audience. Please, when you take the floor, just present yourself. So if there are no questions or comments at this time, then we will go out for a coffee break and we will convene in about 15-20 minutes. Let's go back at 11:40. Thank you. Carolina Babica from the International Commission of Juries online with us. And we have Judge Cassandra Lange from the Council State in the Netherlands, together in person with us here in the aula. We will start with Carolina. Wait, we will make one more attempt. Carolina is online with us, but currently she's muted and her camera is off. So we will make one more attempt to connect her now, or if not, perhaps we can start with Judge Lange, if we cannot start with Carolina. Okay, then perhaps, yes, we can start with the presentation on the role of the judiciary in safeguarding the rights of unaccompanied and separated children. We can put the presentation. Thank you very much.
We see if it's still. Hey, good afternoon. No, still morning. Good morning. So I'll just skip the line. I'll do my presentation right now. My name is Cassandra Lange. I'm a judge at the Council of State in the Netherlands, in The Hague. And I'm very honored to be invited to speak about this important topic. Oh, sorry, yes. My daughter wasn't. And thank you, Valeria, for the invitation. I'm really happy to be here and also honored to be able to speak before you and in this beautiful Magna Aula of the University of Sofia. Well, for me, I'm going to talk a little bit about the perspective of a judge, how we see the fundamental rights, and in this case, especially the rights of children. But I would like to start by saying that a children's right and access to fundamental rights, where we're here for this project, and in specifically children's rights, starts the moment children enter a member state. And it's of vital importance that the organizations who receive those children, unaccompanied minors in this case, treat them with respect for children's rights. So I think the most important people who are dealing with children's rights are here in this aula, especially asylum organizations, asylum authorities, guardianship authorities, and also lawyers who represent these children in their travel through a new life in a new member state. And of course, I think when I hear the stories, everybody's intentions are really, really well, and but still it's very difficult to decide what is in the best interest of the child. And of course, sometimes things go wrong, and that in the end, you end up with a judge, with a dispute maybe.
So it's also of vital importance to have access to justice, and that lawyers can actually go to a judge to lay before them a dispute about children's rights in an asylum law case or a migration law case. So that's where it all starts, access to justice. And then a judge is supposed to protect those children's rights in a procedure. Let me see. Oh, I should point that way. Maybe the other one. Yes. Oh, this is going too fast. Okay, this is the program. I've got 4 items to discuss with you. I hope it takes about 15-20 minutes, and I will try to speak slowly because I usually speak very fast. So please, if I'm going too fast, raise your hand. I will try to speak a bit slower. First, I'll say something about the job of the judge from my perspective. Then something about age determination. Then how to assess the interests of a child, and then finally how to balance those rights. So in general, I've written an article about the job of the judge in the supranational European rule of law, as we have it in the European Union. And since the coming into force of the Treaty of Lisbon in 2009, we have our own constitution within the European Union, the Charter. And in the Charter, there's a very important article, 47, that says something about the job of the judge. This is actually coming from an old adage, an old proverb, ubius ibi remedium, Latin. And it says, where there's a right, there must be a remedy. But since it is in the Charter, it has a constitutional status, this article. And it is a very important task for a judge. And it says that a judge has to offer effective judicial protection of all EU rights, including the fundamental rights, and so including the rights of children. In a concrete case, also a very important amendment. And so this means that in every concrete case, a judge has to provide effective judicial protection of children's rights. Well, that's easy to say, but what does it entail? It's also very important to realize that if there's a question about what does these rights of children entail, if it's not clear, then you have a constitutional court in Luxembourg for these questions when it comes to asylum or migration related cases. So it's not your own constitutional court or your own Supreme Court or your own high administrative court that handles those questions. It's actually the court in Luxembourg who give answers to these questions. It's important to realize that this only counts when it comes to EU-related rights. That's said in 51 of the Charter. So if there is a question about that, and if you are a judge in last resort, like I am, then there's an obligation to ask these questions. If you're a judge in a first case, a first instance, then you have a competence. But if you are the last judge and there's an unclarity about what a right entails, an EU right, then you have to ask questions. So we have a lot of case law from Luxembourg about this issue, which is quite important. To have access to children's rights, this is the second chapter of my speech. It is of vital importance that you recognize that a child is a child, that you have a minor. And in the Netherlands, we have quite a few cases where third country nationals enter the European Union, for instance, in Italy or in Spain or in especially Greece or other countries around the border of the European Union. And there they claim to be an adult. because they want to travel through. And then they come into the Netherlands and they are registered, for instance, in Italy, we've had a few of those cases. And they are registered in Eurodac as an adult. And we had a lot of cases, a line of jurisprudence in the Netherlands that said that if you're registered in another member states as an adult, you're presumed to be an adult. Then it's up to the third country national who claims to be a minor to prove that you are a minor, actually. And also you have to prove that with official documents. Well, this is a very, very difficult burden of proof for a third country national, because usually the documents are no longer there. So, and the idea was that this comes from the principle of mutual trust. You know the principle of mutual trust, yeah? It means that you can trust, for instance, that the Italian authorities have done good research about the age, and then you can trust that if they register, or Greece or Romania, name a border country, that they have done their research well, and that there actually is cause that there's an adult. So we had those cases, and all those minors who claim to be a minor, third country national who claim to be a minor, they were treated as an adult and had no access to their rights as a child. And the question was how to go about that. So we had a big discussion about this approach of the asylum authorities, if this was a good approach, and if this was effective protection of the children's rights. Well, actually, I talked about this case when Valeria visited us, the Council of State in The Hague, with a group of the people in the Trump project. And back then it was a cliffhanger because I couldn't say anything because we didn't have the judgment yet. But in the meantime, we have the judgment. And that's this judgment. In October 24, we said the principle of mutual trust does not apply in these cases. You cannot rely on age registration in another member state. And it does not shift the burden of proof to the third country national. The burden of proof is still with the asylum authority, the minister in the case of the Netherlands. And he can take into account that this third country national has been registered as an adult in another member state, but that's not enough. You still have to question the third country national why, and also you have to question on what basis this registration was made. Was there a medical examination, or was it just a declaration of the third country national, him or herself? So the burden of proof doesn't shift, and you just have to. So the principle of autonomy is applicable. That's the Rewe judgment for the lawyers. But it means that you have to assess the age according to your own national procedures. And it means that the minister in those cases has to take away the doubt about the age. And if there's still doubt about the age, then you're laughing. If there's still a doubt about the age, you have to assume that it is a minor, and you have to be sure that you offer protection of the children's rights in those cases. So yes, I must say this judgment in the Netherlands had a big impact because it also affected, for instance, if a minor or third country national was placed in a facility for minors or a facility for adults. And there are now pending a lot of cases how to assess, who has to assess the age under our national procedure. So we're not done with this theme yet. Anyway, how to determine the age of the third country national is interesting. The Asylum Procedure Directive says something about that, because the member states may use medical examination to determine the age in case of doubt. So the question is then, what kind of medical examination do you use? I think around the member states, there are a lot of different methods of medical examination. There's no harmonization on that regard. When is there doubt? When do you use, because it's quite an invasive examination, right? Medical examination of age. There are also questions about the liability of those results and which criteria, a lot of questions. And I have for you a very, very recent judgment of the Court of Human Rights in Strasbourg of 6th March, just last week. And there, it was a case about against Belgium. And this was about a bone test. And followed by this bone test said that this lady, it was a female third country national, was, I think, 21.6 years old with a discrepancy of half a year or something. Anyway, she was an adult according to this bone test. And according to that, she was removed from the facility for minors to a facility for adults. And the courts had a few interesting remarks about this. They said, because it's very important to realize that children's rights are not only about the content of children's rights, it also says something about the procedural rights of children. And it also says that you have in your national laws a good procedure how to decide on the age of a third country national. And in this case, the Strasbourg court said, puts very shortly that the procedural rules were not followed or they were not there. In this case, the third country national was immediately gone to a medical test. And just after that, she was interviewed by immigration services. And the court in Strasbourg said that this was not a good procedure. And it's very interesting. And they also said, in this case, I'm not going to say anything about the medical test that is performed in Belgium, which is also a very interesting remark in this case. So question here is, what are the consequences of this, the fact that the procedural rules were not followed? Because they say you can only perform medical tests after interviewing a third country national, explaining the rights. If you can refuse as a third country national a medical test, and you have to explain that, and you can only use a medical test as a last resort because of the invasiveness of this medical examination. And this all went wrong in Belgium. So the question is, what are the consequences, and what is the value of the outcome of this test? So Strasbourg doesn't say anything about it. They just said that there was a violation of Article 8 of the Convention, respect to the right to respect for private life. So I think this might be a cliffhanger. I think you will have to see in your national procedures what the consequences are of not following the right procedural rules in this case. And if you can actually take into account the outcome of the test after not following procedural rules. So interesting. How to assess the interest of a child? It's very important for judges that it always starts, if you want to offer effective protection, judicial protection of fundamental rights in a concrete case, facts are very important. And facts in a case are usually the best to obtain in the beginning, when a child just enters a member state. So the role of the asylum authorities, the guardianship authorities, and the lawyers are very important in this aspect. So they have to gather all the facts and all the interests of the child. And only if that's all completely clear, it's for a judge easier to actually judge or assess whether all those facts and interests are taken into account by making the decision, and to also see if there was a right balance. So I think this is really important. One of the, so the member states shall take due account of the views of the child. This is very important. So this starts in the beginning, as I said. And questions in the Netherlands at this moment are also what place does a child have in legal procedures before a judge? And what's the position of a legal representative, the guardian in a case? Is it a specialist on the interests of a child? Or is it more like an advocate for the interests of a child? How do we weigh the views of the guardian? And also, how in the Netherlands we don't only have a guardian for a child, but also a lawyer. So they have two representatives, so to speak. I think it's organized differently in every member state. So how to assess the interest of the child? In the Convention on the Rights of the Child, it says that the child must be able to express those views freely in all matters concerning the child. And also in the Convention on the Rights of the Child, it says that the child shall have in particular the opportunity to be heard in all judicial and administrative proceedings affecting the child, either directly, either indirectly. And then of course in a manner consistent with the procedural rules of the national law. So this this implicates that there is this assumption that it is organized in your national in your national rules. This is, for instance, not explicitly organized in the Dutch Administrative Law Acts. But Article 24 of the Charter is a little bit different. There it says that children may express their views freely. So, and of course, the child's best interest must be a primary consideration when you're going to weigh those interests. So the question is how to assess the interests of the child. There's a big discussion in the Netherlands at this time. And also we are working on a new judgment on this one, so I can't say too much about this. It's still a cliffhanger again, I'm afraid. There are so the question is, should a child be heard in a court room? There are arguments for and there are arguments against. I put them on the screen. One of the ideas is if a child is able to be heard in a court of law, that the child is participating in his or her own proceedings. That is good for the well-being of the child. It's said that a child can give essential information to be able to determine those interests and to balance those interests. And it's also said that this is actually something that counts also for adults, that if you are part of the proceedings and you have a right to be heard, that you will accept the outcome easier of the judgment, whether it's negative or positive. But there are also arguments contra against hearing children in a court. Are there enough facilities and expertise in judicial proceedings to hear children? Because you have a guardianship who are experts, you have asylum or organization authorities who are experts, who have experts in how to interview children. So this is a question. Is it not too distressing for a child that a child has to appear before a judge to be heard? Is that in the well-being of the child? That's the question. Those are all arguments that parties bring forward in proceedings we are handling now. And is it always necessary to hear the child for the outcome? So those are questions, and we are thinking about that now. At least I think Sharma is going to tell something about the pilots in Amsterdam. So I'm not going to say too much about that, but there is a pilot about hearing children in a child-friendly courtroom. And at the moment, as we speak, there are also amendments for our General Administrative Law Act. There are suggestions that there should be a special article that says that children should be heard also in administrative law procedures. We already have a similar article in civil law procedural rules in the Netherlands, but not in administrative law acts. Okay, well, then finally, well, I wanted to end with this slide because it's one of my favorite books. It's about the Children Act from Ian McEwan. I think I showed it before to the group who was in The Hague. This is about a judge in London, a High Court judge, who has to handle Fiona May. I'm not sure, has anybody read this? Maybe? No? It's, yeah, a few have read it. It's really something to take to holiday. It's not a very big book, and it's beautifully written by Ian McEwan, 2 times a Booker Prize winner. And it's about, he's done a lot of research how the High Judge in England is writing judgments, and in this case about the Children Act. And it shows how incredibly difficult it is to make a good balance in the interest of the child. So what's wisdom when it comes to balancing children's rights? It's not very easy. So this book is a really good. I think I'm almost at the end. Yes, I have an example. I think maybe I should end here. Or do you have? Yeah. Oh, I'm asked to continue. Okay, I've got one example. I think it's about how to balance children's rights. This was a case about a girl who came to the Netherlands. I think, yes, I think she came from Syria, not sure. Anyway, she came to the Netherlands and to live with her cousin, who already had a permit to stay here. And it is a Dublin case, and the state secretary at the time discovered that she had a brother in Sweden. And according to the Dublin procedure, he could ask the Swedish authorities to take over this girl so she could have her asylum procedure in Sweden. But the girl didn't want to leave to go to Sweden to her brother because she had hardly ever seen her brother. She asked him to help her a few times when she was in Turkey in the facility. And he never responded to her. So she wanted to stay with her cousin, where she was raised by her grandmother and her cousin. So that was more like a sister to her. So she didn't want to go to Sweden. She was at the time 15 years old. But the state secretary said, well, the Swedish authorities accept it. So again, the principle of mutual trust says that I can trust that it is in the best interest of this girl to go to Sweden. And the girl has to prove that it is not in her best interest to go there, which is, again, quite a difficult task to prove. So we had a case about that. And then we said, well, Article 8, paragraph 1 of the Dublin regulation says it's up to the state secretary as part of the balancing of the interest to gather all relevant information and circumstances in an individual case. So it's up to the state secretary, even if the Swedish authorities said she can come, you still have your own task, your own responsibility as Dutch state secretary to balance those weights. So the burden of proof stays with the state secretary. No mutual trust principle is playing into play. You have to listen to the girl. So we had a hearing, and this girl, by then I think 16, was in the courtroom. She was very hesitant to speak, but in the end she did want to say something, and she explained to us very eloquently and very clearly she really didn't want to go to Sweden, and that she wanted to stay with her cousin, and that she was already integrated. She was there already 2 years, and she got all the necessary facilities and guidance to pick up her life again. So in the end, let me see. In the end, we said that she could stay in Netherlands with her cousin. And that was also because there was not much information from Sweden about the situation of the brother, who had written a letter that he really couldn't take care of his sister because he had a family and he didn't have any money. So she really was not very welcome there. So balancing all those interests, we decided that she would stay. But it's a balancing act every time again. And again, you need all the facts and circumstances to be able to make that balance of the interests. And that's where you're coming to play, all of you. So thank you. That was my presentation.
Thank you very much, dear judge. You can have a seat here in the panel for the questions that we might have afterwards. It has been extremely valuable for us to hear the perspective of the judge through the case law of the Court of Justice of the European Union that could be seen as a constitutional court. This is one way of looking at it. And with regards to mutual trust, I remembered while listening to the presentation that our professor in constitutional law at this university used to say, remember, the most supreme form of trust is control. And then I didn't understand it. So now I start to understand why she said that. Now we give the floor to Karolina Babica from the International Commission of Jurists. Karolina, thank you for being with us. We see you on the screens and you have the floor.
Thank you so much, Valeria, and apologies, I have actually missed that there was a time difference, but I'm here and I'm really sorry for not being able to be in person there with all of you. It was really great to listen to this very inspiring speech and to the concrete examples of my pre-speaker of the chat from the Netherlands. So thank you very much for that. As Valeria mentioned, I work for the International Commission of Jurists. It is a global human rights organization working towards protecting human rights through the rule of law, and I'm based in the Europe and Central Asia program of the ICJ. We especially focus in our work on access to justice for the most marginalized, and therefore we also see access to justice for migrant children as very important, as they are definitely one of the vulnerable groups whose rights need to be promoted and protected. And we work quite regularly with FAHR in various ways, and we really value this cooperation, and thank you again for also inviting us today. We are currently actually working together on a project looking at strategic litigation of detention or alternatives to detention for children. And the ICJ has previously done also some work looking especially at procedural rights of children in proceedings, be it migrant children, but also children in other administrative or juvenile justice proceedings. And so I will focus on that aspect in the next few minutes. While obviously the substantial rights are of course important, without having an effective access to the procedural safeguards, the rights in itself may become sorry. And we've actually just heard a very good example on a judgment of the European Court of Human Rights who focused very, very specifically on the procedural safeguards. So there is obviously a set of general procedural safeguards for children that are also applicable in immigration proceedings. Those I think are worth highlighting are definitely the right to be heard, the right to legal representation and legal aid, right to information, the right to legal guardian, especially for unaccompanied children, the reasonable time requirement, the right to individual approach, and child-friendly justice approach. And all those rights are interlinked, and often one cannot exist without another. Overall, these rights are binding to all EU member states through the EU and the international legal framework. the national laws must be interpreted in light of the EU Charter and fundamental rights and secondary EU acquis, but also in light of the international law that's binding member states. And one of the main instruments promoting and protecting the rights of children is the UN Convention on the Rights of the Child, and is interpreted through its general comments and the case law of the UN Committee on the Rights of the Child. And I would like to especially flag here the importance of the committee and the general comments or general recommendations of the UN treaty bodies, and in this case, especially the UN Committee on the Rights of the Child. These recommendations or comments are issued by the committee that is composed of independent experts in the field of children's rights, and provide often really important clarification and authoritative interpretation of the treaties. The committee can also review individual complaints. So there is a steadily growing body of case law since the past few years that helps to guide states in interpreting the Convention on the Rights of the Child, and also then through that ensuring that they provide effective protection for the rights of children. Then obviously another crucial source of protection at international level is the European Convention on Human Rights, that oversees the implementation of the rights enshrined in the Convention. And although the Convention doesn't specialize in children, we can see a lot of jurisprudence that definitely also gives some very good guidance in this area. And then, as mentioned as well, we have the EU Charter, EU law as a relevant source in this area, and including some case law of the Court of Justice of the EU in Luxembourg. So I will focus mainly on the right to be heard, and just mention to some extent also the right to a guardian and the right to legal representation. And I apologize if, of course, some of the things are already obvious to all of you, or to most of you. And I'll also be focusing mainly on the international legal framework that is generally the highest level of protection that we have for unaccompanied or separated children at the moment. So the UN Convention on the Rights of the Child provides the right to be heard in its Article 12, saying that state parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial or administrative proceedings affecting the child, either directly or through a representative. The Committee on the Rights of the Child has interpreted the article further in its general comment number 12, saying that specifically migrant and asylum-seeking children must have the right to be heard fully respected. They should receive information in their language, a free guardian, and support to education, health, and asylum claims. The general comment also specified that it requires 5 steps: informing the child of their rights, hearings, assessment of the child's ability, giving proper importance to the child's opinion, and appeals. Just to mention that the European Convention on Human Rights does not specifically recognize the child's right to be heard, but the judgments of the court have introduced child's right to participate through interpretations of, for instance, the Article 8 or Article 6. So, and I think we've heard already quite some of that, so, but it may be adding a little bit on the international legal framework perspective as well to what was already said by Cassandra. What does the right entail? That the child is to be given an opportunity and means to present their views. But not only that, those views also should be given due weight. There must be some effect of their views being heard. It actually happens a lot to us that we hear from practitioners that the child was heard because they have spoken with the child, but that may not mean that this right was really ensured. So the fact that the child has the possibility to express their views, it also must have some kind of an effect. It must have a possibility to really affect the final decision. It does not, of course, on the other hand, mean that what the child's wishes have to be always followed by the judge or the authority deciding, but it has to be their views must be taken into account. That equally must be in place even when the child is not able to express their views verbally. So there are obviously these limiting factors. There is age and maturity, which have to be assessed on a case-by-case basis. So in this case, it's just important also to say that any national law that would state that children can only be heard in court above a certain age will be in breach of Article 12 of the UN Convention on the Rights of the Child. And we see quite a lot such legislation, maybe in civil or in criminal proceedings, that a national legislation is setting an age limit from when the child should be heard in court, for instance. There's also case law further confirming this point, speaking more about the child's capacity to express their views, saying that it is the state party that always has to assume that in each case that every child can express their views. And the child should not be obliged to actually prove that they have a capacity to be heard, to express their views. And we have judgments both from the European Court for Human Rights and also from the Court of Justice of the EU on this specific point. Then, and I think we also already heard that there is some discussion on this in the Netherlands, and I think in many other countries as well. It does not mean that necessarily the child always has to be heard in court. Of course, it can also be quite traumatizing, or there can be secondary victimizations depending on the specific case. But we have also the case Shaheen versus Germany, where the European Court has clearly said that it would be going too far to say that domestic courts are always required to hear a child in court. In this case, the child was, if I remember well, 4 years old and was heard several times by an expert who then produced their opinion, the opinion of the child to the national court. So the court said this was actually enough. It really depends on the particular situation, on a specific case, and that there is no such obligation that the child should always appear in court, in formal settings, etc. As we also heard already, the Article 24 of the Charter of Fundamental Rights of the EU guarantees that the best interests of the child should be taken into account as a primary consideration in all actions concerning children. And there is also the Luxembourg court case law saying that this has to be interpreted always in a way that the child should be able to express their views in legal proceedings. Finally, just to mention on the individual approach, there always must be some basic prerequisites. So first of all, children should be always aware of the relevant information concerning their case, also concerning the potential outcome. And this information should be presented in a language the children will understand, which may be, for instance, this is one example where we may have different wording in the EU legislation, but the international legal framework says this, and that's also in line with the child-friendly justice. Then that it's quite important to make sure also there is an establishment of mutual trust, and that's maybe something also that goes back to the need for lawyers to have sufficient training and to really be trained in child-friendly justice. And finally, there is a necessity to also understand the psychological and social needs of the child. So especially unaccompanied children have, in most cases, come through several traumatic events, starting with the original trauma and then the loss of primary connections, often being uprooted. So I think that's just a very important aspect that has to be always also considered. So just very briefly, in relation to children facing legal proceedings, two critical actors are the guardian, who's charged with the statutory representation of the child by law, and the legal representative, the lawyer who represents the child. So the guardian is a crucial institute to ensure the child's right to be heard. For unaccompanied and separated children, this is definitely very important. The general comment number 6 of the Committee on the Rights of giving an example, an unaccompanied or separated child should only be referred to the asylum or other procedures after the appointment of the guardian. The guardian is in principle, and it will vary in national legislations, but under the international legal framework, it is an independent person who safeguards the best interests of the child and their general well-being. The guardian acts as a statutory representative of the child in all proceedings, in the same way that the parent represents their child. Each unaccompanied or separated child should have a guardian appointed as soon as possible, and states also should make sure that they have the necessary legal framework for that. And the guardian does not substitute the figure of a lawyer, but is actually there to ensure the child's access to legal assistance. So that's actually what you said. There is, for instance, in the Netherlands, there is the child always would have a guardian and a legal representative. So the guardian is ideally placed to serve as a bridge between various actors and identify the needs and vulnerabilities of the children. Ideally, they would be in the center of some kind of a network of professionals who cooperate, who complement each other's competences, and the guardian kind of really taking on the role of a parent that's missing in the case, should be able to ensure that the child has all the necessary access to all the necessary experts and support needed. There has been some important case law in recent years also regarding access to a guardian, and that especially in connection with age assessment procedures. There has been a case, for instance, Darboe and Camara versus Italy at the European Court for Human Rights, where an unaccompanied child arrived to Italy and was not immediately provided a legal guardian. So the court that recognized the child had not benefited from this minimum procedural guarantee that must accompany the age assessment procedure, and that was really the prompt appointment of a guardian. There's also been quite a lot of case law to the UN Committee on the Rights of the Child on age assessment, especially quite a number of cases against Spain. And so there, again, the committee said very clearly that when a child didn't have appointed a guardian before they actually went into the age assessment procedure, this was a violation of the best interests of the child principle. Finally, just to say a few words about access to legal representation. Again, the general comment number 6 of the UNCRC says that in cases where separated or unaccompanied children are involved in asylum or other administrative, judicial proceedings, they should be provided to the legal representative in addition to the guardian. The child also should have free access to a qualified legal representative, even when the refugee status application follows a standard adult procedure. And further, in general comment number 14, the CRC said that the child requires appropriate legal representation when their best interests are formally assessed and determined by courts or other bodies. So definitely the right entails receiving effective legal assistance and representation. The child should be explained their rights, their procedures in a manner they can understand. So also lawyers really need to be specifically trained in children's rights and in working with children. And children should have also access to legal aid, so they can access legal assistance at no cost. And then obviously also when children are detained, they should be given legal aid. Just maybe also one comment on the role of a representative that you also mentioned before, that this is something that's being discussed in the Netherlands. There has been an interesting case, not in a migration-related case, but a case of the UN Committee on the Rights of the Child, I think last year, where actually the representative of the child was trying to act in the best interests of the child. And so in their understanding, they were not bringing to the court what the child was actually saying, what they actually wanted to say, but already decided it's not in their best interests and, acted in this way in front of the judge. And so the decision was indeed that this would hinder the right to be heard of the child, and actually the role of the representative may not always be to decide on the best interests of the child. And it can be sometimes confusing because obviously all the professionals have to act in line with the best interest of the child. So it can be sometimes quite subtle, and there is quite some also interesting discussion. What is the role of each representative of the child specifically? So I'll stop here. I'll just say that it is important to see the interconnectedness of the legal frameworks, and especially the binding nature of international human rights law for EU member states, through them being also part of various international treaties that they have signed, that they have adhered to, but also through the EU Charter on Fundamental Rights. So I also feel there may be opportunities for further litigation, especially when the EU Pact comes to place, as there are sometimes discrepancies between the EU law and the international legal framework. And that is something to come, and hopefully we can also work together on this in the future. Thank you.
Thank you very much, Carolina, for this overview and also elaborating on the procedural rights of children, which is very important in order to access the rights that we have stipulated in the law. Now we have the possibility to hear comments from the other participants or any questions that you'd like us to discuss. Okay. We shall give you the mic. Herman.
Thank you. I have two questions for both speakers. No, one question for one speaker and one question for second speaker. First question for Ms. Lappe. I think you said about child participation and talking with a child from the judge's perspective, that you may wonder if it is valuable for your own information. To collect your own information to decide on the case. But what I always understood from Article 12 of the CRC is that it's not really about that, but more to offer the child the possibility to express his views. So that's the question, how you look at that. And the question for Carolina, I think you mentioned a case from Holland about the role of the representative, and I was just wondering what case that is. Very simple question.
I didn't really get the second question, maybe again?
No, that was for Carolina.
Oh, that's to Carolina.
Yeah.
Okay. I'll concentrate on the first question. Well, I think you're right. The question as to what the purpose is of a child to be able to freely express itself in a case concerning his or her. This purpose can be twofold. For one thing, it's about the right of a child to express his or her feelings or opinions freely. So that's about the child wanting to tell something. At the same time,
a purpose can be that when a child does something, you gather information. So I think both things are true in essence. So it might be interesting. I told you earlier that there are procedural rules in asylum law cases and rules about the content. The procedural rules are also important. And part of procedural rules is that there is a possibility for a child to express his or her opinions freely. But at the same time, this counts for all levels, I think, not only for a judge, but also early on in a procedure when a child just arrives in the United States, asking for asylum, for instance. It already starts there to be able to express your opinion freely. And of course, you can gather information from that. And I think in an ideal situation, all the information to be gathered is in that stage already, because the information is fresh and more trustworthy overall. And the longer it takes after something happens, the information gets more maybe blurred or influenced by other influences. But in the end, when a minor comes to a judge or a third country national who claims to be a minor, it's still true that you can also gather information. So the purpose is twofold. That's my answer. Thank you.
Thank you very much. With regard to the second question, Carolina.
Thank you. Yes, it is a case at the UN Committee on the Rights of the Child, and it's called BJ and PJ versus the Czech Republic. And it was a complaint about these children being moved from their home against their will, actually to some kind of a residential unit for treatment of their psychological and psychiatric needs. And yeah, it is an interesting decision of the committee, delivered in May 2023.
Thank you very much, Carolina. Any other comments or questions from the participants? Okay, and then I would like to thank once again to our speakers for their contributions on the role of the judiciary and implementing legal safeguards of children. Now we're going to have a lunch break, but we have a proposal for the participants here in the aula to make a group photo before lunch here in the stairs that lead to the aula. So we kindly invite you to the group photo before lunch.